Imagine you are sitting at your desk at work. Your phone buzzes. It is a message from your cousin back home in Lahore. He says, "Did you see the news? America just froze visas for Pakistan. What does this mean for my petition?" You tell him you will look into it. You put your phone down. And then your own stomach drops because you suddenly remember. Your mother's I-130 petition has been pending for 14 months. Your brother's F1 student visa interview is scheduled for next week at the embassy in Islamabad. Your own green card application is sitting inside a USCIS office right now, and your country of birth is listed clearly on every single page. You open your laptop with shaking hands. You type the words into the search bar, and what comes back hits you like cold water. 75 countries, a State Department and USCIS coordinated action, a visa freeze affecting nationals from Pakistan, and 74 other nations, tied to a national security and vetting review directive that went into effect with almost no public warning. Your hands stop moving on the keyboard. You stare at the screen, and you think, is my case dead? Is my family's future in America finished? Is everything we sacrificed, every dollar we saved, every year we waited, gone because of a policy decision made in Washington that we had no warning about and no vote in? This video is about exactly what happened, what it means for you right now, which cases are affected and which ones are not, and most importantly, what legal tools and strategic steps exist to protect your case and your family during this freeze, because I am telling you clearly, panic is not a strategy. Information is. Let me start with what actually happened, because the confusion in the community right now is being made significantly worse by people who are reporting half the story. In early 2026, the Trump administration issued a directive through the State Department and coordinated with USCIS that initiated an enhanced security vetting review for nationals of 75 designated countries. Pakistan was among the most prominently named countries in public communications around this action. The directive was framed around what the administration described as inadequate information sharing cooperation from these governments and heightened national security screening requirements consistent with executive authority under INA Section 212F, which gives the president broad authority to suspend or restrict the entry of any class of aliens when he determines their entry would be detrimental to the interests of the United States. This is the same statutory authority used for the travel bans in the first Trump term, which were ultimately upheld by the Supreme Court in Trump versus Hawaii in 2018. That legal foundation is real. The authority exists, and the current administration is using it more broadly and more aggressively than before. What the freeze specifically triggers is a hold on the routine processing and issuance of certain immigrant and non-immigrant visas for nationals of the designated countries, along with an enhanced administrative processing requirement at consular posts that effectively suspends normal interview scheduling and visa issuance timelines until country-specific security review protocols are completed. For some countries, the review is expected to take weeks. For others, analysts tracking State Department processing patterns are projecting that the administrative processing backlog could extend well into late 2026 or beyond. For applicants from Pakistan specifically, the impact hits family-based petitions, employment-based visa applications at consular posts abroad, student visa renewals and new applications, and diversity visa processing for the current fiscal year cycle. Now here is the trap. And it is a trap because it is invisible to most people until they have already fallen into it. The trap has two sides. The first side catches people who are abroad and waiting. They see the freeze announced. They panic. They start calling the embassy every day. They hire unqualified consultants who charge them thousands of dollars to file emergency motions or submit congressional inquiries that are not appropriate for their stage of case, wasting money, and sometimes actually drawing negative attention to cases that were otherwise moving through the system without problems. The second side of the trap, and this one is more dangerous, catches people who are inside the United States with pending USCIS applications and who incorrectly assume that the freeze does not affect them because they are already here. they stop monitoring their case. They miss requests for evidence because they have stopped checking their USCIS online account. They travel internationally, not realizing that if they leave the country during the freeze period, their re-entry may be blocked or significantly complicated depending on their current visa status and the specific restrictions applied to their nationality. This is the mistake that ends cases permanently. Leaving the United States without understanding exactly how the freeze interacts with your specific visa category and your pending application status is one of the most irreversible errors an immigrant can make right now. And the third layer of the trap, the one that the government does not advertise, is the administrative processing designation itself. When a consular officer places your case in administrative processing, which is formally noted on your case status as 221G under the INA, there is no statutory deadline for how long that processing can take. The government is not required to resolve it within 30 days or 60 days or 6 months. Cases have sat in administrative processing for years. And during that time, your visa is neither approved nor denied. You cannot compel a decision through most normal channels. If you are abroad, you cannot travel to the United States. If you were counting on that visa to reunite with your family or to begin employment, that timeline is now completely undefined. This is where families break down. This is where people make desperate decisions. And desperate decisions in immigration, as I have seen in 6 years of working these cases, almost always make the situation worse. Here is your legal shield, and I need you to understand this clearly, because this is where most of the community is getting incorrect information. The President's authority under INA 212F is broad, but it is not unlimited. Federal courts have consistently ruled that even under a presidential proclamation restricting entry, individuals who have already been approved for immigrant status, or who have a facially valid visa already issued, or who fall into specific statutory exemption categories, retain legal rights that cannot be unilaterally eliminated by an executive directive. If you are inside the United States with a valid non-immigrant status, a pending adjustment of status application, or an approved immigrant petition with a visa number currently available in your priority date category, you are operating under a different legal framework than someone who is applying at a consulate abroad. Your pending I-485 adjustment of status application is processed domestically by USCIS, not by a consular post. And consular-level visa freezes do not automatically halt domestic adjustment of status processing. That distinction is critical, and most people in the community do not understand it. Additionally, under current USCIS policy and the Administrative Procedure Act, which governs how federal agencies must operate, USCIS cannot simply stop processing a properly filed and accepted application without issuing a formal notice to the applicant. If you have a pending I-485, I-130, I-140, or any other properly filed petition and USCIS has issued you a receipt notice, you have a procedural right to receive notice of any action on your case, including any hold or suspension of processing. If processing is stopped without notice, that is a potential basis for a legal challenge through the federal courts. Your attorney can file a writ of mandamus, which is a federal court action that compels a government agency to perform a duty it is legally required to perform if your case has been unreasonably delayed beyond standard processing times without explanation. Now let me deal directly with the misinformation that is spreading across Pakistani, Egyptian, Eritrean, Libyan, and other affected community groups on social media right now, because what I am seeing online is genuinely alarming in terms of how wrong and how dangerous some of it is. First false claim: your approved I-130 petition is now canceled because of the freeze. False. An approved I-130 petition is a USCIS determination that a qualifying family relationship exists. That approval is a separate legal finding from visa issuance. The freeze affects visa issuance and consular processing, not the underlying petition approval. Your I-130 remains approved. What is affected is the timeline for converting that approval into an actual visa at the consulate. Second false claim circulating heavily on TikTok right now: you should immediately refile your application under a different category to avoid the freeze. This is not only wrong, it is potentially disqualifying. Refiling under an incorrect category can create misrepresentation issues on your record. Do not refile anything without explicit guidance from a licensed immigration attorney. Third false claim. If your country is on the list, your green card application inside the U.S. is automatically denied. This is false. Domestic adjustment of status and consular processing are legally distinct processes. A freeze on consular visa issuance for your nationality does not automatically translate into a denial of a domestically filed adjustment of status case. Fourth false claim. Hiring a notario or a visa consultant to make calls to the embassy or USCIS on your behalf will speed up your case. This is not only false, but potentially damaging. Only a licensed attorney or an accredited representative recognized by the Board of Immigration Appeals has the legal authority to formally represent you before USCIS or in immigration court. An unaccredited consultant calling on your behalf has no legal standing and in some documented cases has actually triggered additional scrutiny on client files. Here is your action plan, and I need you to move on this strategically and in the right order. Tonight, your first step is to log into your USCIS online account at myaccount.uscis.gov and check the current status of every pending application associated with your family. Look for any request for evidence notices, any interview scheduling updates, or any case status changes that may have occurred in the last 30 days. During periods of policy disruption, USCIS sometimes issues notices that go to the address or email on file and never get seen until significant deadlines have already passed. Second step, if any family member is currently abroad and has a visa application or interview scheduled at a U.S. consulate in one of the 75 designated countries, do not assume the appointment will proceed as scheduled. Check the specific consulate's website directly for any posted administrative notices about suspended processing or rescheduled appointments. Showing up for a canceled appointment can sometimes result in complications if the officer finds grounds to take adverse action on the file during the interaction. Confirm before traveling to any embassy appointment. Third step, if you are currently inside the United States on any non-immigrant status, whether it is an F1 student visa, an H-1B work visa, a B-2 visitor visa, or any other temporary status, do not make any international travel plans until you have spoken directly with a licensed immigration attorney and confirmed exactly what your re-entry rights are under the current directive as it applies to your specific nationality and visa category. The rules around re-entry for nationals of designated countries are nuanced, and they can change between the time you leave and the time you try to come back. An immigration attorney needs to assess your specific situation before you purchase any international ticket. Fourth step, if your case is in administrative processing at a consulate abroad and has been there for more than 6 months, ask your immigration attorney about the viability of filing a writ of mandamus in federal district court. This is not the right tool for every case, but for cases that have been sitting in unexplained administrative processing well beyond normal timelines, federal courts have, in multiple documented instances, ordered the State Department to take action on cases that had effectively been abandoned administratively. Your attorney can evaluate whether the timeline and facts of your case meet the threshold for this type of legal action. Fifth step, document everything. Save every USCIS notice, every email confirmation, every appointment letter, every receipt notice. If you are communicating with the embassy or USCIS in writing, save copies of every submission and every response. In immigration proceedings, documentation is the difference between a case you can defend and a case you cannot. If the agency later claims you missed a deadline or failed to respond to a notice, your documented paper trail is the only thing that can rebut that claim. Sixth step, connect with a licensed immigration attorney today, not after you see what happens, not after the situation develops further. The landscape for nationals of designated countries is shifting week by week based on court decisions, State Department updates, and potential congressional action. Having professional representation means someone is monitoring those shifts on your behalf and advising you before a change creates a crisis in your case rather than after. My name is James. I am a senior immigration analyst with 6 years of experience, and on Immigration News Today, I do not give you opinions. I give you the survival strategies that keep families together. What is happening right now with this 75-country visa freeze is serious, it is real, and it is moving faster than most families realize. But serious does not mean hopeless. It means you need accurate information, a clear plan, and professional support. The people who navigate this successfully will be the people who acted on facts instead of reacting to fear. Immigration rules change overnight. A single court decision in a federal district court in Washington or California could alter the scope of this freeze within days. A new State Department cable could modify which categories are affected. A congressional hearing could shift the political calculus around specific country designations. You need to know about these changes the moment they happen, not 3 days later when they are already affecting decisions you could have made differently with better information. That is exactly why my WhatsApp community exists. I send instant alerts the moment something significant changes, before it becomes a full video, before it makes the news cycle. The link to join is in the description below this video right now. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration News Today right now and turn on notifications. Staying informed is no longer optional, it is essential. I am James. Protect your status. Protect your family. I will see you in the next update.